So Lillian is a world-leading academic in the field of internet law. She has taught on these topics of information technology, e-commerce law, privacy law, internet law, since the last century, and and been involved with law and AI since 1985. She is the chair in Law, Innovation and Society at Newcastle University. She's a partner in the Horizon Digital Economy Hub at Nottingham, a fellow of the Institute for the Future of Work, and I'm very glad to say that at the Alan Turing Institute, she leads on law and AI. Welcome, Lillian.
Hi. Sorry, everything has gone wrong this morning, which is why I look faintly weird, because my monitor display has also failed, so the camera's in the wrong place. Sorry.
You look great, Lillian, don't worry. I'm going to go straight into a few questions, if that's all right.
Sure. Sorry about that. Yeah.
So I think one of the topics that's on many people's minds, particularly we saw in the last session, is generative AI, ChatGPT and the like. I wonder if you can comment on how the potential EU AI Act deals with those kinds of technologies.
Yeah, this is a big problem. I mean, I think people are waiting for the draft EU AI Act to sort of come in and provide guidance, a sort of gold standard almost globally for how to regulate AI and make it safe. But unfortunately, after they finished doing the first draft, along came generative AI, more or less. So it wasn't really contemplated within the framework of the AI Act. And this is really a big problem, because the way the AI Act works is quite sensibly, I think. It doesn't regulate the technology per se, like it doesn't say, you know, no more machine learning or whatever, because that would clearly be crazy. It regulates uses of the technology, or intended uses, right? So the way it works is it sets up a list, which is not entirely the best way to do it, but it does. It sets up a list of what it calls high-risk systems, which have intended uses. So if you build a system that's intended to be used as a hiring system, or if you build a system that's intended to be used in the courts to assess the risk of people fleeing and therefore, you know, you don't give them bail, or if you build a system that's intended to be used to assess creditworthiness, right? Then these all fall within the high risk categories in the AI Act, right? And then they are regulated notably by the fact that you have to make sure that the training sets and the testing sets are of good quality, are representational, you know, are not full of errors, all these things that people have complained about AI, right? But then along comes generative AI, and it doesn't have an intended use. It's, you know, the whole idea is that it's general, that it can be used for a million things. I mean, ChatGPT can be used to make a child's birthday greeting card, as has been said, or write a poem. But it can also be used to disseminate fake news, you know, or to be used for plagiarism in an educational context, right? So you end up with this real conundrum in the AI Act as to how to regulate these technologies without either under-regulating or over-regulating. And, you know, you might want to come back at me about that, but I'll just say the biggest conundrum, I think, then that is now facing the regulators drafting this piece of legislation is, should we try to regulate the providers of the models? So the upstream providers, the Googles, the Amazons, the Microsofts, right? Which is, you know, perhaps one of the obvious ways forward, because they have the power. They know what data they have, you know, they're in control. And they make the money out of it. But it's almost impossible, in fact, it probably is impossible, for them to anticipate all the intended uses and therefore all the intended risks, right? So the alternative approach, which, you know, the tech lobby is obviously behind and other people are behind, is to regulate the downstream users of it, the deployers, right? The people who are putting it into applications. But that is also really problematic, because these people don't have as much power and a lack of transparency, right? Because often these are proprietary systems that you're calling on through APIs. So the downstream developers are in a very disempowered position. They don't know what's in the data sets. They don't know the quality of the data sets. They don't know how they've been weighted. They don't know all kinds of things, right? So how are they going to fix the systems, as it were, so that they're not biased, so that they don't spew out fake news? So it is a really difficult problem. And right now, the European Parliament this week is debating this and is trying to find a compromise, right? Which I can talk about if you want.
Well, yeah, let me just clarify that these technologies pose a challenge, particularly with respect to this idea of intended use. So these are Gen AI in two ways. They're generative, but they're also somewhat general. And this is quite new and poses challenges in every jurisdiction. I'd love to hear what you think about how it's likely to be handled in the UK, but just before we go on to the UK, still on Europe, as well as the AI Act, there are all these other bits of legislation going on, like the e-commerce directive, Digital Service Act, even the good old GDPR. Do any of those weigh in here? Are they relevant?
Yes, they do. I mean, actually, the action at the moment, particularly in the US, is mostly around copyright. I mean, probably people have seen headlines in the press about this. So we have 2 or 3 really major pieces of litigation kicking off. I mean, who knows? They might settle, they might disappear. But because particularly the image models that are getting also a lot of press, we hear a lot about GPT, but we also hear a great deal about DALL-E and Midjourney and Stability AI. And Stability AI, for their sins, have decided to make their whole model open source. So in fact, it's the one that's vulnerable to attack because people can see what's inside it, and people have been analyzing it and saying, well, you have got 2% of your data set is from living artists whose copyright hasn't expired, and they're mad as hell, to paraphrase, right? So in a way, you've got this strange paradox right now where all of the incentives, kind of risk-wise, are to keep your technology proprietary and closed and non-transparent, which is probably as a society what we don't want, actually. Yes. I would venture to say. I mean, people might want to comment on that. We have a general feeling, don't we, that open source leads to more innovation, it leads to more scrutiny, it leads to a better product, et cetera, et cetera. So, but at the moment, the drivers are the other way. So what we're seeing is a number of really high-profile copyright cases being brought by Getty, the photo Shutterstock type people, and also a bunch of artists suing Stability primarily for stealing their stuff, for stealing their IP. And that is going to be a real bun fight, because, again, without getting into too much copyright, there are defenses on kind of both sides, or attacks on both sides. So Stability particularly are going to claim that their use of the copyright images art was fair use, right? Which is not a UK concept. I'd just like to say that, although people think it is. It's an American concept. It's much wider than anything we have in the EU. Yeah.
Maybe you could just take a step back. Maybe people may not be completely aware. Can you maybe just tell us briefly, what is that? There's this enormous court case, Getty against Stability. It's maybe, they're suing them for, is it billions or even trillions of dollars? I'm not quite sure. It's a very large amount. Why are they suing Stability? Why are they not suing other people? What's going on?
Well, that's what I'm just saying. They're suing Stability primarily because Stability do have a discourse, a rhetoric about being open source, and you can take Stability, as I understand it, I haven't done it myself, and port it to your own laptop, right? And run it there and fiddle with it, so people are doing incredibly innovative things with it, which is the sort of thing we might want to encourage, right? There's loads and loads of downstream applications coming from Stability because of this. But it means that they're open to scrutiny, right? And some clever people have managed to take a certain percent of their data set and analyze it and find out who's in it, by doing image comparisons and so forth. And they have found out that, a number of notable living artists whose style is very recognizable are in that data set, right? So yes. This is why everyone is suing Stability. Whereas you might say, well, why don't they sue DALL-E? Why don't they sue OpenAI?
Yes.
Because they can't find out. They can guess from doing, searches and putting in prompts, but they can't actually find out. So that's why Stability is the #1 target right now.
Yeah, so as background, probably most of you know Stability was a recent entrant, but a really important one, trying to make all of these large models open source and available to everyone. They have a popular image generation tool like DALL-E or like DALL-E 2. You enter text and it produces an image. And unfortunately for them, it turns out that people have demonstrated, you'll see this if you Google them, that if you put in certain prompts, I think particularly around maybe football players, it will generate an image which actually creates, because of the training data it's used, it will create an image that will have a mark on it saying copyright Getty Images or something like that. So it doesn't look good for them on that front.
It doesn't. If I could just say to that, actually, it's fascinating because yes, that does appear to be the smoking gun for Getty, who are very pissed off. But there is also a theory I read just the other day that because what these systems do is they simply grab what seems like, the next most likely, the next most probable pixel or whatever to put into the image, that maybe it's putting the Getty watermark into images where that watermark did not exist.
Yes.
So it does seem to show by implication that they've gobbled up a lot of images that had Getty on them. But some of those are open to the world. So this is going to be very confusing evidence. The fact that an image has been spewed out of a footballer with Getty on it does not necessarily mean that they copied that image. So it's going to be fun.
Absolutely right. And also, if they'd gone to a bit of trouble to make sure that they didn't reproduce a Getty image copyright, presumably that's worse, but it would be deceptive, or it's not quite clear.
It's very difficult, and I think one solution to this, obviously one solution is going to be to fight it out in court, but that's going to be very expensive. One solution should be to have a move towards some kind of watermarking in images, I think. And a lot of people are working on that, including OpenAI. Yes. But as I'm sure a lot of our audience knows, putting in an image that's a GIF as a watermark is trivially easy to remove. So this is very, very easily gamed. It could also be inserted by people who want to, drop other people in it, and try and prove that they were stealing when they weren't. So I know that there is an open standard that's being adopted by people like Adobe, who make Photoshop, and various news organizations who are very worried about the authenticity of their brand, of it being poisoned. So the BBC, the Washington Post, I think Canadian Broadcasting, a few others, I think, are working on a watermark standard that is less easily able to be removed. That's more like a digital signature, right? Yes. And if you do remove it, apparently it leaves evidence that it was removed. So this is a very current field of innovation, which might help, at least for copyright purposes. But it's going to be an arms war. We've already seen this with deepfakes, right? We've already had, 7 years, longer, of people making deepfakes and other people making detection systems so they can filter them out. And then the people who make the deepfakes work out what they did and they change it slightly, and that's what you get. You get an arms war. And usually the people making the deepfake are ahead. So I think watermarks are not going to be a complete solution, is my guess, as a non-technical person.
Lynn, we've touched on a whole range of topics, and you've already talked a bit about EU and US legislation. What's going on in the UK?
Not a lot, actually. Interestingly, a guy from the US came over, Alex Engler, who's an expert from the Brookings Institute, and he talked to a lot of people because he's involved in the US policy developments. And he said, it's strange. No one really talked to me much about Gen AI. I noticed that it's been shoehorned in, maybe, into the document on kind of a roadmap for pro-innovation technologies or something that came out yesterday with a foreword by Patrick Vallance. So it has like a paragraph on generative AI in it. And oddly, I thought it might talk about quality requirements of the kind that we see in the EU AI, about getting the data set right, getting the training sets right. But it doesn't. It just talks about copyright. So this appears to be the UK's main plank at the moment, or at least the one that they've developed enough to show to the world, maybe, which is this idea, which I was going to come to, of allowing the use of copyright materials in generative AI without having to go through getting a copyright permission for every item, which would clearly be impossible because what these models do is soak up the entire internet, more or less. So they're talking about an extensive text and data mining exemption in copyright, okay? Which is an idea that was floated ages ago by one of the UK law reform bodies, and then was shot down in the House of Lords fairly recently, because particularly I think the music industry were terribly worried about what the implications would be of essentially allowing massive copyright infringement for the purpose of AI. So now we seem to have stage 3 of this, in which the government, because I really thought that was a done deal, that had been shot down in flames, having an extensive commercial data mining exemption, but now it seems to be back as of yesterday.
Can I wonder if it's already going to stage 4? Because I don't know if people saw there are models like Stanford's alpaca model, which was announced last week, which has been predominantly trained on the output of ChatGPT rather than trained directly on the data itself. Does that in any way protect them from copyright claims or other claims?
I doubt it. This is where it really gets beyond me. I'm not actually a copyright expert. I think there might be discussions about whether it's a derivative work, maybe whether it's an adaptation. I very much doubt it gets them off,
Right.
I think it's a very interesting experiment. And of course, because it's open source, it's out there. And what you've really got, it seems to me, stage 4, I've been talking about this to people, is the file sharing world. Right? When we had Grokster and Napster, remember all that? And LimeWire, and everyone could download materials and infringe copyright at home, in a completely distributed fashion. And that's what we're going to have. Now the genie is out the bottle. I've been saying this ever since Stability AI arrived as a model you could port to your own machine. The genie is out the bottle, and everyone is just going to soak up stuff and do their own copyright infringement.
We've only got a couple of minutes left. I wonder, can you briefly comment, Lillian, going beyond copyright, about data protection concerns? Because clearly these algorithms are potentially digging up possibly private information about people or connecting items together.
Yeah, this is my personal grief, because what I really am is a GDPR expert. And of course, the US right now doesn't have a federal data protection law. There is a strong law actually in California, so it's odd in a way. But I think because they don't have a federal privacy law, they have all the literature that's come out so far, and 99% of the journalism has never mentioned data protection, which is quite odd. If you think about these models as gobbling up copyright material, which people have talked about a lot, they are also gobbling up giant amounts of personal data. I mean, most photos are personal data. Arguably, paintings are personal data, and all kinds of things, right? So yeah, what's the grounds on which this data is being gobbled up? And even if you find a ground which is conceivably possible, a lawful ground for processing, you've still got all the other aspects of the GDPR, which is where it goes much further than copyright. Because notably, you've got a right to be forgotten, right? Which got a lot of press a few years back. You've got a right to erasure. You've got a right to erase your personal data. And the implications of that, which is something Michael Veal and me wrote about 5 years ago, not knowing Gen AI was going to come along, is that maybe you've got a right to destroy the model. Maybe that would be insane, I think, but that might be argued. Or maybe you've got a right to remove your data, and then you might say, well, if you've removed your data, what good does it do if they don't retrain the model? So maybe they have to retrain the model, and that has enormous implications. It's expensive, it's time consuming, it's bad for the environment because you're using all that energy. So there's a huge can of worms there about the GDPR, and I think that's the next thing I want to write about myself.
Gosh, brilliant. Well, lots of questions raised there. I'm sorry we have to come to a close, but please join me in thanking Lillian for joining us.
Thank you.